The Supreme Court has reserved its order on petitions filed by Bharti Airtel, Vodafone Idea and Tata Teleservices seeking to rectify the adjusted gross revenue demands raised by the Department of Telecommunications. Meanwhile, the DoT has been asked to reply to the claims of arithmetic errors in AGR calculations, even as the top court reiterated that its last year's order, which barred any recalculation of AGR dues, will remain in force and is not going to be revoked. Seeming inclined to dismiss petitions filed by telecom companies on reducing AGR demand, the three-judge bench of Justice LN Rao, Justice SA Nazeer and Justice MR Shah will now hear the case after 2 weeks and consider DoT's reply. Telecom companies have maintained that rectification is different from reassessment or recalculation of AGR dues, claiming that DoT was hesitant to revise its raised demand or rectify errors unless allowed by the Apex Code. With no fresh instructions from the DoT, Solicitor General Tushar Mehta sought a time of a few days to reply on the alleged arithmetic errors in DoT's calculations, while maintaining that it may be a little hazardous for him to make any statement as of now. Pointing to last year's verdict, which had asked RCom to keep existing bank guarantees alive till the entire payment is made, he informed the court that the bankrupt telecom company was yet to comply with the order. Claiming that they were not blaming the DoT or seeking a review of the court verdict, telecom companies submitted that the calculated AGR demand is replete with duplication in revenue addition, errors of omission and commission, and arithmetic errors, which has led to double counting and inflated the AGR demand. Vodafone Idea has the highest total AGR liability amongst telecom companies at over rupees 58,000 crores. Appearing for Vodafone Idea, senior lawyer Mukul Rohatgi urged the court to allow DoT to examine the arithmetic and calculation errors which may lead to some rebate for the telecom company, claiming that it is not a fly-by-night operator and has a liability spread over a period of many years. Vodafone Idea sought to place all paid entries before the DoT as it maintained that many of its payments were not reflecting in government records. Appearing for Bharti Airtel, senior lawyer A.M. Singhvi maintained that the company is fully compliant with the court order and has paid over 10% of its pending AGR dues of around rupees 18,000 crores, while submitting that its payments and deductions were not considered by the DoT and it was purely by oversight. The company made it clear that it cannot be asked to pay the amount again due to errors. Tata Teleservices argued that like any other tax or due, AGR has to be in line with the law. Terming rectification as a matter of right in any assessment or reassessment, the company told the court that the quantum of dues will not be significantly affected by reassessment. In October 2019, the top court had upheld DoT's definition of AGR and had asked telecom companies to clear all dues within 3 months.